We follow rules every single day, but what is it that turns a simple rule into a law? What gives it that special power, that authority? It seems like it should be an easy question, but it's actually one of the biggest and oldest questions in all of philosophy. So let's get into it. And let's just dive right in with the big one, the question that gets to the absolute heart of the matter. Is an unjust law still a law? Seriously, think about it for a second. Think about a law you believe is just plain wrong, morally wrong. Does it stop being a law just because of that? Or is being a law something totally separate from being good or bad?
All right, so where does this question even come from? Well, this isn't some new debate we just came up with. This is an age-old philosophical showdown, and it really comes down to two major ways of thinking. So, on one side of the ring, you've got natural law theory. This is the idea that for a rule to be a real law, it has to be morally good. It has to line up with some kind of higher universal justice. And on the other side, you've got legal positivism. And this view says, nope, a law is a law if it was made by the right people in the right way, like a government or a court. Whether it's a good law or a bad law is a completely different conversation.
The natural law idea goes way, way back. St. Augustine summed it up perfectly with this famous line, "An unjust law is not law, period." For a natural law theorist, you just can't separate law from morality. They're woven together. Think about what that really means. If a government passes a rule that violates a fundamental moral principle, it's not just a bad law. It's not a law at all. It's a fake. But then the positivists came along with a totally different take. The jurist John Austin put it about as clearly as you can. The existence of law is one thing, its merit and demerit another. For a positivist, to figure out if something is a law, you just have to look at the social facts. Who made the rule? What process did they follow? Do people obey it? Judging whether it's a good law is a separate second step. Okay, so if you're a positivist and you can't use morality as your yardstick, what do you use to identify a law? The answer is simple. You look at its sources. You trace it back to its origin to see if it's the real deal. A fantastic real-world example of this is international law. I mean, think about it. There's no world president or global police force to decide what's moral for everyone. So instead, as this guide from Georgetown Law explains, the whole system works by countries agreeing on a specific set of sources that tell them what counts as international law. And if you look at the rulebook for the International Court of Justice, specifically Article 38, it lays it all out for us. It lists the official sources of international law. And you'll notice there's nothing in there about whether a law has to be just or fair. It's all about where it comes from. So let's break these down real quick. First up, the easiest one to understand, treaties. A treaty is basically a contract between countries. It's a formal, written agreement. If a country agrees to it and signs on the dotted line, then they're bound by it. It's a law for them because of that clear action, that social fact of agreement. But here's where it gets really fascinating. A law can actually come into existence without ever being written down. This is called customary law. It happens when countries start acting in a certain way over and over, consistently, because they feel like they have to. They believe it's a legal obligation. That shared belief, which has a fancy Latin name, opinio juris, is what magically transforms a common practice into a binding law. Okay, so the positivist source theory sounds pretty neat and tidy, right? Look for the source, find the law. But it's got a big problem. What happens when you're in a tough spot, when the rules are vague, or they contradict each other, or there's no rule at all? This is where the debate gets really, really good. And this is where a brilliant legal philosopher named Ronald Dworkin steps into the ring. He looked at this problem and came up with a powerful challenge. He said, hey, when judges are deciding these really hard cases, they aren't just making stuff up. They're actually figuring out what the law already is. But to do that, they have to look at more than just the rules from the official sources. Dworkin's whole argument hinges on this really cool distinction he makes between rules and principles. A rule, he said, is all or nothing. Take a speed limit. If the rule says 65 and you're going 66, you've broken the rule. It's black and white. But a principle is different. A principle is something like, no one should profit from their own wrongdoing. It doesn't give you a clear-cut answer. It has what Dworkin called a dimension of weight. In a specific case, a judge has to weigh that principle against others, like the right to inherit property, and decide which one matters more in that situation. So for Dworkin, a judge isn't just a referee calling fouls based on a rule book. They're more like an author writing the next chapter in a long-running novel. They have to make their chapter fit with everything that came before, all the past decisions, but they also have to try to make the story as a whole the best, most just story it can be. So for him, you absolutely cannot separate what the law is from what the law ought to be. I know. This all sounds super philosophical and abstract, right? But trust me, these big ideas have a huge direct impact on how our actual legal systems are built and how they work. Let's take the United States as an example. The US generally uses what's known as a dualist approach. You can think of it like two separate bubbles, one for US domestic law and another for international law. For an international rule to become a law inside the US bubble, it has to be officially brought in or incorporated by a domestic action. And you can see this source-based positivist thinking written right into the U.S. Constitution. The Supremacy Clause is crystal clear. It says that treaties are the supreme law of the land. Why? Not because they're necessarily moral or just, but because the ultimate source of law in the country, the Constitution itself, says they are. And that brings us right back to where we started. Natural law theory says your own moral compass is the ultimate test. Legal positivism says you have to look to the source, the authority that made the rule. And Dworkin says it's a mix of both, a deep interpretation. So the final question isn't just for philosophers and judges, it's for all of us. When the laws on the books clash with our deepest sense of right and wrong, what should guide us?